Next is bankruptcy. I personally have never filed bankruptcy. I learned about bankruptcy from my bankruptcy attorney when I first got into debt and was looking for a solution. He told me about bankruptcy and told me about debt settlement. Because I have never filed bankruptcy and never gone through that process, I have no personal experience to relate to you. I am not an expert on bankruptcy. If you are thinking about filing bankruptcy, I beseech you, talk to a bankruptcy attorney, talk to your financial advisor, talk to your accountant. There are innumerable repercussions and actions and reactions and consequences and things to do that I do not know about and cannot inform you of. So get more expert advice than I can offer. The best that I can do is relay to you, for the purposes of this course, my understanding of the bankruptcy process to use it as a balance against the other information that I'm delivering. In 2005, President Bush signed the Bankruptcy Abuse Prevention and Consumer Protection Act, which addressed bankruptcy specifically and made it more difficult for more borrowers to file what's called Chapter 7 bankruptcy. In Chapter 7 bankruptcy, you could have debts entirely expunged and push those people through a series of test criteria that they were measured against towards Chapter 11 and Chapter 13 bankruptcy, which require structured payoffs of your debt over time. Although any bankruptcy would still put an end to all collection attempts and phone calls and legal proceedings if you were in one. As I understood it from my bankruptcy attorney, even Chapter 7 bankruptcy would now no longer allow for a debt to just be completely wiped away through the bankruptcy process. Instead, as I was described it, filing bankruptcy now puts you into a sort of financial receivership, my attorney's term, not mine, where the court assigns sort of a super creditor to your financial life. And that super creditor now has the right to go through all of your finances, all of your bank accounts, all of your assets, all of your holdings, all of your debt, all of your income, and make determinations by him or herself as to what assets can be disposed of and what money from that can be used to pay off your debts. So filing bankruptcy doesn't just make your debt go away, it just turns over the solution of your credit card debt to the court. I understand in every jurisdiction, in every state, there are different limitations to how much you're allowed to keep. At the time that I was looking at bankruptcy in California, around 2008, 2009, I was told you could keep $22,000 in cash and a car worth up to $3,000. That may or may not be the case now or in your jurisdiction. But for me, it became a numbers game. When I learned about debt settlement, I was able to say, if I go through this process of debt settlement, will that leave me with more assets at the end of the process or less? And if I do it myself, will I be more successful at it? Or will bankruptcy handle the situation better for me? As I understood it, the 2005 Act was intended to stop borrowers who had a tremendous amount of debt, but also a tremendous amount of assets, from filing bankruptcy to have their debt wiped away while they retained possession of all their assets. Frankly, I understand that. I have said my course is not for people who make a great income and are capable of handling their debt in the way that they intended to when they started. I'm not encouraging people to use debt settlement to alleviate debts that they could otherwise pay comfortably and still take care of their life in a financially responsible way. And it's fairly clear that the law favors lenders when it comes to a borrower who has a high amount of debt and a high amount of assets. On the other hand, if somebody has a high amount of debt and no assets, the bankruptcy law clearly favors the borrower. Because in this case, somebody would be able to turn their financial life over to the supercreditor, who would see that there are no assets to pay off the debt, and therefore the creditors wouldn't get anything for their debt. This is a negotiating point when it comes to negotiating settlements with your lenders. If you truly are in a situation where you may file bankruptcy because you have very little or no assets, and the lender recognizes that if you do file bankruptcy, they're going to get nothing for their debt, reaching a settlement, even if it's a lower one, is to their benefit. So this is why I do these 6 ways to get out of debt and compare them across all the criteria, because what each one has is reflected in the other when it comes to making a choice. And before we get into the 6 criteria directly, I also want to point out that bankruptcy is a court proceeding, which means when you file bankruptcy, it is now part of the public record compared to something like debt settlement, which is a private proceeding between parties. And unless you were to publicize your debt settlement negotiations with a lender, they would remain private. So with all that said, as kind of an introduction to bankruptcy, what it is and how it works, let's look at it across the 6 criteria. First, how much time will it take? In theory, this could be one of the quickest processes for getting out of debt for you, in that from the moment you file bankruptcy, if you meet the test criteria and you are approved by the court to do so, it would stop all collection attempts and court proceedings and lawsuits immediately. So from your perspective, it would happen very, very quickly. How long the court is actually engaged in your bankruptcy in terms of selling off your assets to pay off your debts could take quite a while longer. I have no idea how long for you because I don't know what your situation is and what assets you have to sell and what debts you have to put them against. But that process could take a while. Your process in terms of filing bankruptcy and being relieved of the collection attempts would happen very quickly. How much will it cost in principal and interest and commissions and fees? There's a fee associated with filing bankruptcy, which may be anywhere from a few hundred to a few $1,000s in your city or state. You will have attorney's fees when it comes to the filing. I know there are some online bankruptcy filing services that will just do the paperwork for you inexpensively. If you were to actually hire an attorney to do it for you, that hourly rate might cost more. If you have to go to court and have an attorney with you, that hourly rate might cost more. In terms of how much it will cost you in principal and interest, I can't say. Again, it depends on how much assets you have to pay down your debt and how much your state or jurisdiction allows you to keep. But for the most part, I would expect filing bankruptcy to cost you a good portion of your assets in settling out your debt. If you have no assets, it's going to cost you a lot less. The purpose of bankruptcy these days isn't to alleviate the debt. It's to alleviate the collection attempts and the lawsuits that will no longer apply, but the debt itself will still be paid off by the court from your assets. How much time and effort personally for you will it take? Some. Bankruptcy doesn't happen on its own. You will need to do the paperwork to file your bankruptcy. With that will go a full accounting of your assets and debts and income. You'll see in a few more videos when we start getting in to the Easy Business Plan that I have you do a full accounting of your life. So if you go through this entire course, especially the second time through where you actually do everything and you complete that full accounting of your life, your bankruptcy attorney will thank you because you will have all of that paperwork done and prepared and make it very easy for him or her to discuss with you how a bankruptcy might apply to you. So you have all that information prepared for you in this course, but you'll have to do it anyway if you file bankruptcy. How will you feel about yourself in filing bankruptcy? Again, this is going to be a personal choice. As I said earlier, I believe that a lot of people have been wrongfully burdened with a sense of shame around using a legal, legitimate method of getting out of debt. I have no judgment for anybody who files bankruptcy. It's a strategy. As I've said, businesses use it all the time. So if you are using it as a strategy and you've run the numbers like the CEO of the corporation of you, if you're treating it like a business and it's the business choice you make, I don't feel you should have any negative emotions around it at all. On the other hand, if you're watching me thinking, oh, I do feel a little bit of, I don't know about bankruptcy, then I, of course, would recommend that you work through those emotions in the chapter that we're going to do later about emotions, so that if you do choose bankruptcy, or for whatever choice you make, that you're making it from the choice of a business person running the numbers like a business and not letting emotion guide you one way or the other. The effect on your credit score will be drastic and poor. Bankruptcy goes onto your credit report. My understanding is that it stays there for 7 years. I've heard that from bankruptcy attorneys. I encourage you to talk to your financial advisor or bankruptcy attorney about what it might be, so you can weigh that into the choice you make about whether or not bankruptcy is the right route for you. And lastly, that brings me to how much control you will have, which is none. Once you've filed your bankruptcy, you are turning your financial life over to the courts, who will be entirely responsible for determining which assets to keep, which assets to sell, how to distribute the money gained from the sale of any asset. You will no longer have any control over what happens in your financial life. So to me, even on the other end of your bankruptcy, even when you emerge from your bankruptcy, I believe that the negative emotions you may be suffering now, any pain or fear or anxiety or guilt around being in debt or the stress of dealing with the debt, that just filing bankruptcy and turning your financial life over to somebody else will not necessarily alleviate that. All that said, under the right circumstances, with the advice of a qualified bankruptcy attorney and your financial advisors, filing bankruptcy is a strategy and may be the right strategy for you if you go through the 6 criteria and determine that the criteria of bankruptcy are the best for your situation.